as Liz said, thank you for tuning in to this webinar. The title may not be particularly appetizing, but I, as a barrister who represents companies and in some cases employees throughout the country, I find this area particularly interesting because it's in the very centre of that Venn diagram between employment law and commercial law. Before we crack on, just to tell you a bit about myself, as I say, I'm a barrister. I practice from Broadway House Chambers. We're based in Leeds and Bradford, but we're sent all over the country. This afternoon I'm on my travels to Aberystwyth, which I can't wait to drive that 4.5 hours, thinking about restrictive covenants, I suppose. But there are some of the cases that myself and other barristers in my chambers have been in, and we have very happy to have received quite high praise in the past. Just moving on, I have to give this disclaimer. This presentation is for your information purposes only. If anyone requires advice on any of these issues, then go to your solicitor and they can seek advice from barristers such as myself. Often, as you'll find out from this presentation, the issues surrounding restrictive covenants are complex, and I can't stress enough, it is vital as employers you're on the ball in this regard, because if you think your business is protected, you may be quite shocked if an employee leaves and actually tries to breach that, because often restrictive covenants such as the ones we're going to be talking about today are found null and void. On that cheery note, let's have a look at topics to consider. Well, I'll give you an overview of the law on restrictive covenants, and I don't want to bore you with law and go into sort of legal cases and principles in too much depth, but I want to just flag up some issues to get you thinking and to go and seek out that advice and have discussions internally about your own contracts and your own policies. And in that theme, I will point to common problems that you find with the enforceability of non-compete, non-dealing and non-solicitation clauses. And we'll end by looking at alternatives to problematic clauses, such as garden leave provisions in contracts, which are often a healthy alternative to restrictive covenants. And we'll look at the enforcement of restrictive covenants and practical steps you can take to obtain injunctions and be remunerated for, or compensated for rather, any breaches that your employees may commit. As we go along, do please ask questions, type in the chat box, share your experiences. If you've got a particular problem, share it, and we'll discuss it, and that will keep the topic alive. So, moving on, the overall themes that you need to keep in mind when discussing this is employer versus employee. So, on the employer's side of things, you have probably trade secrets. You probably have certain methods. If you're in a manufacturing industry, you have a certain way of doing things. You may have a particular recipe if you're a food manufacturer, or in a case I did recently, you had a particular formulation for glue which held the cardboard in the center of toilet roll together. That was a particularly interesting case, and the judge was entertained throughout. But nonetheless, it was a recipe, if you like, for a particular glue. The employee left and took it with them and tried to woo their new employer by saying, "Look, employ me, and you've also got this way of doing things." And we tried to stop them doing that. And you had two competing sides. You had the employer, they want to protect what they've spent a lot of money developing, and the employee, who is generally free to contract and do what they like once they've left your employment. So those are the two competing interests. And another area which often there's a lot of litigation over is intellectual property. If you take, for example, as an employee, some marketing material which your employers had produced, that is their intellectual property, and you taking it as an employee may land you in hot water. But that's outside the scope of this talk, and it's perhaps something, Liz, we can cover on another day. But those are the themes I want you to have in mind. Moving on, we'll have a look at what restraints in contracts of employment are. And you see on the screen there, it's a promise by the employee that upon leaving the firm's employment, he or she will not set up in competition with employers or solicit their customers to enter the firm's, to enter employment into the employment of a rival. That is the basic sort of proposition that we're dealing with. It's this promise that's made, and quite often that promise is to, as it says there, not take customers or try to take customers, or even go and work for a rival. What is absolutely key to bear in mind is that this is a contractual promise. Contract law applies, and so in the same way that if I buy something from you and that something is illegal, for example, that contract is liable to be void. So, for example, if you have an employer who contracts with a 15-year-old to work full-time hours, and there is a restrictive covenant in there, and the employer tries to enforce it, that contract is illegal and is liable to be set aside, and in the same way that covenant sort of dies with it, if you like. And so the covenant is valid only if the contract is legal. Enforceable clauses may become dubious in the event of contractual breach as well. So if as an employer you do something to breach the contract of employment and you have a claim of, as an employee, a claim of wrongful dismissal, the contract is repudiated. It's that a repudiatory breach is accepted by the employee, and the contract comes to an end. And in the same way, the restrictive covenant will come to an end. So that's something to bear in mind. These restrictive covenants are contractual promises. It's give and take on both sides, which is something we'll come to on the next slide in a moment. But it's not an overarching duty that this restrictive covenant issue. It's confined to what is in the contract. You often have implied terms, such as the implied term of confidentiality, which we'll have a look at in a moment. But do bear in mind that this is a contractual issue. On the next slide, just moving on, you'll see there, in the same way that this is contractual, in contract law we have this principle called consideration. And essentially that is, if I buy something off you, I'm giving you money and you're giving me the product. If it's just a one-way street and I'm just giving you something for nothing in return, you haven't given me consideration for what I'm giving you. So that is the basic principle of consideration, and many of you will be familiar with this, but for those of you that are not, that's a very basic explanation. Now, if a restrictive covenant is contained in a contract of employment from the outset, then generally clauses that don't have or that have a restrictive covenant in are unproblematic, because there is consideration both ways. An employee is giving you their services, you are paying them. If, however, you introduce a restrictive covenant during the currency of their employment, so they're 2 years in and you think as an employer, well, right, we better get a covenant drafted, and you give it to them, it may be that there is no consideration for that. So you're giving that restrictive covenant to them, expecting them to agree to that. They're giving you that promise, but they're not getting anything in return. Some employers, and such as this case that you'll see, the case of Sendall in 2014, some employers will say, well, at the same time we gave that restrictive covenant and wanted that promise from our employee, at the same time as that we also gave a pay rise. But if that pay rise isn't directly linked to that restrictive covenant, you're likely to come unstuck in that. In that the court will likely hold that because it's not linked, it's not consideration, and that was the case in Sendall. So do be very wary if you're an employer trying to introduce some sort of restrictive covenant during the currency of an employee's employment, then you need to give them something in return, essentially in return for their promise. Okay. Liz has just asked, what if you don't? If you don't, then they will say that there's no binding contract, and therefore you can't rely on the restrictive covenant, and that is what the court will likely say. In a similar vein, if there is a TUPE transfer, and TUPE is a minefield, and I would encourage you to look at the other webinars on TUPE, and this will be Regulation 4.4 will be covered in more detail. In fact, there was a webinar last week on TUPE. But if there is a restrictive covenant which is causatively linked to the transfer, then under Regulation 4.4, it will likely be considered unenforceable by the new employee if the employee breaches it. Moving on to the next slide, Lizzie's just frantically trying to find a link to the to the TUPE event last week. There we go. We'll look at restrictive covenants in some more detail, and we'll look at what the doctrine, as we call it, is. Before I do that, I've just seen a question from Margaret. Does that mean you can't restrict unpaid volunteers? No, not necessarily. If they are happy to enter into the agreement, and you give them something in return, then you're fine. Obviously, it's not going to be pay, but you'd need to think of something, Margaret, to give them in return for their promise. It may be that you, I don't know, I'm thinking off the top of my head, but you agree to give them limited remuneration, or you agree to put them in a certain shop if they're volunteering in the shop that they would like to volunteer in. It's very difficult to think on the spot of examples, but that is something you would need to consider. You need to consider giving them something in return for their promise. Okay, moving on to the doctrine itself. The traditional rule is that all restraints are void unless they're justifiable. Okay. The courts have been unclear what to do in this regard. What is the default position? They've wavered back and forth, but it's pretty much settled law now that you cannot restrict someone after their contract has come to an end unless you can justify that restriction in the circumstances. Okay, and what you have to do is look at what facts existed at the time that the contract was entered into. And I'll give you an example. If, for example, you wanted to restrict a quite senior manager in that they were not to go and work for another competitor within a 20-mile radius, for example, at the time of contracting, if that 20-mile radius was justifiable in the circumstances, and we'll look at how you justify that in a moment, then at the time that's fine. And when you come later to try and enforce that, you're going to be fine in my view, because you can justify the circumstances, you can justify the restriction at the time of the contract. The manager may try to argue that, well, hang on, we're 10 years down the line here, and that 20-mile radius contains many more potential new employers for me, and so assessing that restriction now, it's grossly unfair. But as Pat Systems, that case tells us, you have to look at whether or not the clause can be justified on the facts as they stand at the time the contract was entered into. And in 9 out of 10 cases, that will be when the employee took up employment. When looking at whether or not the contract is justifiable, you have to have a look at whether the employer has rights which need protection. And in this regard, you'll look at things such as whether or not they do truly have trade secrets, or whether they truly do have connections which need to be protected. If an employee has had no contact with 90% of your client base, it's likely to be not justifiable to restrict that employee to contacting all clients of the business. It may be more justifiable to say you can't contact those those clients that you have had direct dealings with when pursuing your duties with us. And you would have to look at also the employee's position within that business. So if you have an individual who is, as I say, restricted to a very small client base, or if you have for example, a receptionist who may deal with all the clients but doesn't really deal in depth with their particular accounts with you, then in those circumstances, it would be unreasonable, in my view, to restrict that employee to contacting any clients. But it wouldn't be necessarily unreasonable to restrict a manager that oversees all client accounts, because they will have much more in-depth knowledge of the accounts and, for example, the price they're being charged when it comes to supplying the employer supplying services to that client. So you have to have a look at what the legitimate interests of the company are, and this whole system is designed. The law in this respect is designed to be protective and not penal. Okay, so there are no legitimate interests which need protection from the employee in question in those circumstances. Then any covenant in restraint of trade will be struck down. So you must have your legitimate interests which need protection. If that interest exists, in those circumstances, the employer may impose a restrictive covenant, but that restrictive covenant must be no more than is adequate to protect the interest in those circumstances. And as I said earlier, an example of that is if you have a restriction which stops that employee who's left contacting any clients at all, or, for example, practicing in a 10-mile radius when all of the, if it's a butcher's, for example, and you restrain a butcher from practicing or trying to get clients within a 10-mile radius, most customers of that butcher will live within a 10-mile radius. That's just the way those businesses work. If you did the same for a solicitor, for example, then solicitors have clients in a 50-mile radius, and so it would be much more reasonable to impose that restriction on the butcher much more narrowly than it would the solicitor. In addition to all of that, there is a public interest test when looking at restrictive covenants and whether or not they are enforceable. If the covenant represents a fair balance between the employer and employee, it may be said to be declared void in the public interest. And an example of that is where an employee, an ex-employee, risked his pension if he competed with a former employer. And it was to be held contrary to the public interest in that case. This is the case of Bull versus Pitney Bowes. It would be contrary to the public interest to deprive society of the skills of the worker concerned. And so what they said in that case is that this particular worker has such an important skill set that it wouldn't be in the public interest to restrain them in the way that that particular restriction was drafted. So you have that public interest test as well. So before we move on to how courts construe these covenants, what's important to bear in mind, the headline from those those points is that you must have a legitimate business interest that you're protecting, and not just being petty that you don't want employees of yours to go and work for a competitor. There must be a reason behind that. And then you have to look at whether or not the restriction as it's drafted and taking into account the circumstances that exist at the time that that particular contract was entered into, whether or not it goes beyond what is reasonable to restrict that particular employee from doing what you don't want them to do. Okay. Does anyone have any questions arising from that? I can see Carol's typing, so before I move on, I'll wait to see what if that's a question. I have to say, with all of these, it's very, very fact sensitive. So, as I said, a restriction stopping a butcher doing his trade within a 10-mile radius is likely to come under much more scrutiny than applying that to a solicitor. That's an example of it being quite simply fact sensitive. Carol, in theory, you can restrict a person from selling a product in an area for a new employer, but you would have to link that back to why. Is that product particular to your company, the ex-employer? Is that product particularly special? If it's a product that they first brought to the market or they've created, for example, then you're much more likely to be able to say we don't want anyone else, any of our old employees going and selling it for a new employer. But that restriction would have to be, as I said earlier, no more onerous than is necessary in the circumstances. This is really Margaret's question. Could part of the covenant be deemed unreasonable, for example? Yes, Margaret, and that's what I'm going to move on to now. So that's a very good link. We'll have a look at hiving off parts of the contracts, hiving off part of a restriction and keeping another part. And we'll do that now. So construing the covenant. In theory, normal rules of construction apply to a restrictive covenant. So what you would have, what a court would try to do is give effect to the intention of the parties. Both parties may have very different versions of what the intention was, but words will be given their ordinary meaning. For example, if a restrictive covenant says they won't enter into the sort of business that this company it carries out, you would look to the contract as to, well, what sort of business has been carried out. That's the sort of thing that you would be concerned with. A key point, as I said earlier, is have these covenants drafted by solicitors. It is vital that they are confined to the particular interest you're trying to protect and don't go too far. Okay. The court will always try to interpret the terms realistically. Okay. One particular case concerning a milkman restricted him from plying his trade in the local area for a particular dairy. Now, what he said is, well, I could move down to Devon, for example, and one of the people who was in that particular area, that 10-mile radius, may move all the way down to Devon, and I wouldn't be able to serve them. That doesn't legitimately protect my ex-employer. Now, in those circumstances, the court said, well, we're not going to strike the restrictive covenant down on that proposition, simply because it's an unlikely chain of events, and the covenant would, in those circumstances, operate unreasonably. But that said, it's highly unlikely that one of the people you're restricted from selling to for say 12 months after your employment's ended, it's unlikely that they will move down to the same area as you. So in all of those circumstances, we're not going to interpret the restriction unrealistically. And what we have more recently is a case of Profit versus Huggett. Now, I'm not going to read all of that to you, but an employer, the headline from this is that an employer can expect a hard time from a court if it's simply made a mistake in drafting the clause. Now, if, in Huggett, they restricted an employee selling something which only Profit could actually sell, so it made no commercial sense to restrict someone from going out and selling a product which they wouldn't be able to sell in any event. What the company said was, no, we didn't just mean the product that only we can sell. We meant all products, but the restriction didn't say that. And the court said, well, we're not going to do the drafting for you. And this is the importance of getting restrictions drafted properly, because a court is unsympathetic if your contractual provision, your restriction, is drafted poorly. They are not going to redraft it, or in these circumstances say, oh, actually what the employer meant was products of this type which are found on the market nationally. We think from reading the contract what they meant was the particular product that they sell, and that doesn't make sense, but it's not our problem, essentially. It's well worth a read, that case. It's not particularly hard going. It's not too legalistic. It's a good case which gives an overview of the law in this area as well. And as I say there, the court will not do it for you. A line has to be drawn between interpreting the contract to give effect to what the parties intended. So, for example, interpreting the word business in light of what the rest of the contract says, but they won't go as far as to rewriting the clause. Okay, so the former is permissible, the latter's not. What we do have, however, is the blue pencil test. The blue pencil test, it's worth having a read up on, because it can get particularly complicated, and we could do a whole webinar just on that. But essentially, what it's looking at is whether, and this goes to your question, Margaret, whether you can sever particular terms linked to restrictive covenants. And I'll give you an example. In the case of Sadler, the employer was to receive quite a handsome pension sum. He was going to be paid a gross sum 12 months after his employment terminated, but as long as he didn't go and work for a competitor. Okay. Now, the restriction, therefore, was linked to the benefit, and arguably there were two terms there, two separate terms. The court said the restriction's far too wide. Okay, I won't go into the terms of the restriction, but the restriction is far, far too wide. However, we don't think, if we strike that down, if we strike the restriction down, we don't think there's anything wrong in maintaining the benefit that the employee is going to get. Okay, but they did say there were three conditions, and I'll tell you what those are. In the first place, the enforceable provision had to be capable of being removed without the necessity of adding or modifying the wording of what remained. So that goes to the court's not going to redraft the provision for you. The second condition was that the remaining terms continue to be supported by adequate consideration, and that goes to the consideration point again. Okay, so that benefit he was going to get still required him to give consideration for that. Okay, and the third condition was that the removal of the unenforceable provision did not change the character of the contract, so it became not the sort of contract that the parties entered into. So in those three conditions, and it's worth having a read of Sadler, in those three conditions, if those three conditions are satisfied, then you can hive off an unreasonable restrictive covenant, which is liable to be struck down, but maintaining the benefit to the employee. And that's something, as employers, you should be aware of if you do have any benefits linked to a restrictive covenant. And finally, the case of Marshall added a fourth condition, and that was that the severance must be consistent with public policy underlying the avoidance of the offending term. Okay, so in other words, the benefit must still be in line with public policy. All of that, as you will have heard, is quite complex, and we're in dangerous waters as employers. You're in very dangerous waters if you do have these restrictive covenants. It's very difficult to avoid any sort of challenge to them by employees when they leave. And I've been on many, many cases in which employees say, well, the restrictive covenant simply doesn't mean what you're saying it means, or actually I've been told it's far too wide. And so what other options are there? Well, the main option, and I would encourage anyone to take advice on the alternatives that are out there and alternatives that are available, but one of the main options is having a garden leave term. You'll all have heard of it, and the definition, or a broad meaning, is on the screen. It typically provides that in the event of the employer or the employee giving notice to terminate the contract, the employer may require the employee to spend all or part of the period on notice at home, and thus gardening, which is where the term gets its name, keeping the employee effectively away from competitors, or keeping the employee from disclosing confidential information to other parties because he's not working for other parties and he's still bound by the rest of his contract. So garden leave clauses, that they are complex. It doesn't necessarily get away from the complexity, but they're often considered a healthy alternative by the court in any event. And again, this comes down to Margaret's question. If you have a gardening leave term for 12 months, I do some cases with football managers, and often there's a gardening leave term for 12 months. What the court can do is say, well, we're going to restrict it to 6 months because we think that's reasonable. Now that the court would not do for a restrictive covenant because they're not going to rewrite them. And that's one of the key points I said earlier. A court won't rewrite a restrictive covenant to make it more reasonable. Okay, it may interpret it in a certain way, but it's not going to rewrite it to make it more reasonable. With a gardening leave term, a court can, and often does, say, we think 12 months in the circumstances, given this employee's position, given what's at stake, and given the employer's business interests, we think 12 months is far too long, so we're going to restrict it to 6 months or 3 months, as the case may be. Okay, so gardening leave terms are, as I say, a healthy alternative, and even if you end up in court over a gardening leave term, you've always got that fallback position of asking the court or inviting the court to say, okay, 12 months is too long, can we restrict it to a lesser amount of months? If, on the other hand, you do end up in court because someone has breached an ex-employee has breached a restrictive covenant, then you're going to want to seek some remedies. Those remedies are generally breach of contract, because remember, it's a contractual promise that's been made to you as the employer, and you will say, we want damages for breach of contract. That may take the form of simple compensation so from the losses that's been caused to you, or it may be you need an account, so the court will need to inquire as to what actually is the loss caused. So, for example, an employee, if they've taken a client list of 100 and they've actually taken 3 clients away from you, what is the cost of that to you? In certain circumstances, when it's simply too difficult to do that quantification exercise, what the court may do is say, well, how much would an employee likely pay to you to get out of that? That, in my view, is quite a nice fallback position if it's simply too difficult to quantify the loss directly. one of the main remedies that's sought is an injunction. Now, you may seek an injunction, but in reality, your hearing may not take place for 3 months, in which time your ex-employee has got your list of clients and is doing what they like with it. In those circumstances, you will likely want to seek an urgent hearing for an interim injunction. Quite often, the interim injunction will be for an ex-employee to give the client list back. The question then is, well, what's the use of having a final hearing because we've already got what we want? So in those circumstances, often the interim injunction renders the final hearing otiose. So the key point I'm trying to get across here is the hearing of interim injunctions is often key in the final disposal. Often ex-employees give undertakings at these hearings at the door of the court, which is a promise to the court to say, fine, I won't do what I've been doing, I won't go and poach some more clients, and if they breach that, they're in contempt of court. That's also quite a nice way to dispose of proceedings. But the practical consideration it is really the cost of all this. It's incredibly expensive to bring these proceedings quite often, and you can, certainly at final hearings, get into quite lengthy arguments about whether or not, in the first place, the restriction is enforceable, whether or not they've actually breached it, whether or not what they've done falls within the definition of what they're not allowed to do. It's quite costly. So make sure, in other words, make sure your covenants are as tight as possible and are as specific to the employees as possible, because in those circumstances you're more likely to be able to point to what the business interest is you're wanting to protect, why you say the protection that you've got there is adequate in the circumstances, and when you go to get your interim injunction, I just will be impressed if you have quite a specific restriction there, rather than these wide sweeping restrictions that are found in standard contracts of employment, which you can get from agencies and people off the internet. You'll have these wide restrictions which apply to directors and managers in the same way as they apply to the cleaners. And plainly, that is not a sensible view or a sensible process to have in mind or to have in place. So make sure your contracts are specific to the employees, and in those circumstances, you'll be in a much stronger position when it comes to seeking that remedy if you need to. Okay, so that's led me on to the question stage, and I've got a question from Julie Marion. If the restrictive covenant is not taking employment with our clients, but at the end of the employment we leave the employee to go to work for the client, we can revoke the clause. However, my question is, can we just revoke the clause for one specific client and not all of our clients? You can. You can waive, in my view, you can waive that restriction to the extent of that particular client only. Excuse me, but that would need to be done by way of a variation of that contractual clause. Okay, and what I would do is I would take specific advice with that, Julie, because what you don't want to do is set a precedent for other employees wanting to go and work for other clients, and you don't want to have this failure of consideration which renders the whole restriction useless. In other words, you would need that consideration, so you need that give and take with the employee when you're trying to when you're offering the new term which excludes from the restriction that particular client. Okay, so I would seek advice on that. That is generally my view, that you can do it, but you need to make sure your contract is specific, well drafted, and that there is consideration. Okay, and it may be that you need to do something to prevent other employees knowing about it and setting a precedent, so make sure it's clear to that particular employee only. Okay. Does anyone else have any questions? Yeah, so Liz just said that there are certain aspects around this webinar which there's a lot of scope for having another webinar on. The blue pencil rule is key. It's very, very important to be aware of that. And also intellectual property. I do some intellectual property work. There are people who specialise, solicitors who specialise in just intellectual property because it's such a big area. In this context, I do intellectual property work, and I'll be happy to give a talk on that. But I think by the looks of it, having a blue pencil talk in the first place would be a good idea. Having a talk on the blue pencil rule, and then maybe doing something with intellectual property. Okay, great. Well, everyone, thank you for listening to me. I'm now going to go on my way to Aberystwyth. Wish me luck, and I'll speak to you all soon. Thank you.
Thank you, Adam, and thank you, everybody. Some lots to take in there. I don't know about you, but I've got a few action points on my list now, things I need to go away and look at. Very, very quickly, thank you, everybody, for your questions and for your thoughts there. This week, developing people using 7-20-10 model, as I talked about earlier, and the breakfast one will be if you can achieve anything, if you change your behaviour. And there's a link there. I'm just going to for the archived webinars, and we look forward to speaking to you all soon. Thank you all very, very much, and have a really nice afternoon. Take care.